That sound. It's all it takes for the police to get the power to toss your entire car on the side of the road. It's a K-9 alert, and the law treats it as undeniable probable cause. But what if it's built on a lie? A Chicago Tribune analysis of traffic stops dug into the data and found something shocking. When a drug dog says there are drugs, they're only right 44% of the time. That means for every 100 searches based on a dog's nose, 56 of them come up completely empty, leaving innocent people violated. So how did a 44% success rate, a failing grade by any standard, become enough to shred your constitutional rights? Hi, I'm J. Scott Smith, a North Carolina criminal defense attorney that's been practicing law in North Carolina for over 18 years. And in this video, we're going to talk about the 44% lie that lets cops search your car. Let's dive in. The stop that changed everything. It started with expired tags. Back in June of 2006, a man named Clayton Harris was pulled over by Officer William Wheatley in Florida. As Wheatley approached the truck, he saw that Harris was visibly nervous and spotted an open beer can in the cup holder. Based on this, the officer asked if he could search the truck. Harris said no. This is a critical moment in any traffic stop. For those of you who have been watching my channel for a while, you guys know that you absolutely have the right to refuse a search of your vehicle. But exercising that right often triggers what comes next, the K-9 unit. Officer Wheatley walked his German Shepherd Aldo around the truck for what's called a free air sniff. This is legal because the Supreme Court has decided that you don't have a reasonable expectation of privacy in the air outside of your car. As Aldo encircled the truck, he alerted at the driver's side door handle. For Officer Wheatley, that was the ballgame. In the eyes of the law, a K-9 alert magically transforms an officer's hunch into probable cause. It gives them the legal authority to search your entire vehicle, everything you own inside it, and even you. The search of Harris's truck didn't find the drugs Aldo was trained to detect, but it did turn up over 200 pseudoephedrine pills. Those are ingredients for making methamphetamine. Harris was arrested, and his case started a journey that went all the way to the United States Supreme Court, forcing the entire legal system to look at just how reliable these police dogs really are. The junk science of the K-9 alert. Before we get into what the courts decided about Clayton Harris, we need to talk about the dog. The whole justification for a search rested on one big assumption, that Aldo's nose was a reliable scientific tool. The data, however, shows that this idea is just fundamentally wrong. The 44% accuracy rate isn't an outlier. It's pretty much the norm. In New South Wales, Australia, police data from a 10-year period showed that drug dogs were wrong about 75% of the time, leading to tens of thousands of fruitless searches. An analysis of one Illinois state police program was even worse. Dogs alerted on 28 different cars, but drugs were only found in one. That's a 96% failure rate. Think about it. If a medical test were wrong that often, we'd call it malpractice. But in policing, it's called probable cause. So why are these dogs so often wrong? It boils down to three main reasons. First, there's unconscious handler cueing. Dogs are masters at reading people and live to please their handlers, but many K-9 training programs don't use double-blind testing, the scientific gold standard for avoiding bias. In a double-blind test, neither the dog nor the handler would know where the drugs are. Instead, the handler often knows the location and can easily give the dog subtle clues without even realizing it. A slight pull on the leash, a change in tone, a shift in posture. The dog isn't smelling drugs, it's reading its owner. Second, look at the incentives. One court case looked at a K-9 that got a reward from its handler every single time it alerted, whether drugs were found or not. And what was the result? The dog alerted on a staggering 93% of deployments. When a dog learns that barking equals a treat, it's going to bark. That's not detection, it's a performance. In that same case, the dog's accuracy rating was found to be statistically no better than the officer's own hunches, and a hunch is not probable cause. Finally, police departments have a convenient excuse when no drugs are found. The residual odor theory. They argue that the dog must have smelled the ghost of drugs that were there recently. This creates a perfect, unfalsifiable circle. If they find drugs, the dog was right. If they don't find drugs, the dog was still right. The person whose car was just torn apart is left with no recourse, their rights violated based on an invisible, unprovable scent. Then the Supreme Court makes it worse. This takes us back to Clayton Harris. He fought the search of his truck, arguing the state couldn't prove Aldo was a reliable drug dog. And at first, the Florida Supreme Court actually agreed with him. In a huge decision, the court said the state had to provide real field records to prove a dog was reliable, how many times it alerted, and how many times it was wrong. It was a major win for transparency for a brief moment. It looked like the 44% lie was about to be exposed. But the state of Florida appealed, and the case landed in the United States Supreme Court. In 2013, the Supreme Court delivered a unanimous decision in Florida versus Harris, and it was a devastating blow to Fourth Amendment rights. Justice Elena Kagan, writing for the court, threw out Florida's stricter standard. She argued that forcing police to keep detailed field records was too burdensome. Instead, the court ruled that if a dog is certified and gets some ongoing training, that's enough to assume its alert is reliable. The burden of proof was completely flipped. It was now on the defendant, Clayton Harris, to prove the dog was unreliable, a nearly impossible task without the very records the court just said police didn't have to provide. With that one decision, the Supreme Court gave its seal of approval to the 44% success rate. It locked in a system where a dog's bark, no matter how unreliable in the real world, is treated as gospel, giving police a nearly unchallengeable weapon to conduct searches. A system of bias and abuse. The fallout from this ruling isn't just about the bad science. The K-9 alert has become a tool for enabling bias and, in the worst cases, outright abuse. The same Chicago Tribune study that found the 44% failure rate also uncovered a disturbing racial disparity. The dog's accuracy dropped to just 27% when the driver was Latino. This strongly suggests that K-9s are either used more often against minority drivers due to officer bias, or that handlers are more likely to see an alert that isn't really there when dealing with people of color. Worse, there are cases where K-9s are used not only to detect, but to punish. In February of 2024, officers in Sterling Heights, Michigan stopped a domestic violence suspect. The man was already on the ground and he'd already been tased. While he was surrounded by officers, another officer reportedly urged the K-9 handler to use his dog. The handler then ordered his K-9 to bite the subdued suspect. Michigan's Attorney General charged both officers, declaring that deploying a K-9 on a suspect already on the ground and well surrounded by officers is not only horrific, but illegal. Both officers are now facing trial for assault and misconduct. These aren't just isolated incidents. They expose the darkest potential of the K-9 unit, a tool of intimidation and violence protected by the legal fiction of the reliable alert. So what does this all mean for you? It means that on the side of a dark road, your constitutional right to be free from unreasonable searches can be erased by a system that is wrong more often than it's right. The Supreme Court's ruling in Florida versus Harris has made it increasingly difficult to fight back against the K-9 search in court. So what can you do? First, always clearly and calmly state, "Officer, I do not consent to a search." While this won't stop a K-9 search, it's vital for the legal record to show you've never waived your rights. Second, stay silent. You have the right not to answer any questions like, "Where are you going?" or "Do you have anything in your car?" Third, if you can do so safely and legally, film your encounter. A recording is one of the most powerful tools there is for accountability. The 44% lie is more than a number. It's a scientific fallacy that's been twisted into law, creating a giant loophole in our most fundamental rights. It greenlights biased policings and violations of privacy, all based on a dog's bark that's less reliable than a coin flip. The courts may not be on our side right now, but awareness is the first step toward demanding change. Share this video. Let people know a K-9 alert is not the ironclad evidence police want us to think it is, because until we challenge this system, 56 out of every 100 people subjected to these humiliating searches will be innocent. But what if there's no K-9 present and the officer walks up to your car and says, "I smell weed"? I talk about that in this next video, what to do when cops say they smell weed. I'll see you over there. And remember, arrested doesn't mean guilty.